Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. The topic for today, the Pennsylvania Superior Court has declared a no-hire provision in a contract between two companies void as against public policy. Now, a no-hire provision is sometimes referred to as a no-poaching provision. It's an attempt by one company to enter into a contract with another company, and the contract says the other company can't poach or steal the first company's employees. Now, this is a case of first impression. The Superior Court in Pittsburgh Logistics Systems versus BMAC Trucking voided an agreement between two companies that prohibited the one company from hiring the employees of the other during the period of their contract and for 2 years thereafter. Here are the facts. Pittsburgh Logistics Systems, it's a shipping logistics company. It has customers, usually manufacturers or distributors, who have products they want to get to market. So they hire Pittsburgh Logistics Systems, and Pittsburgh Logistics finds the carriers, the trucking companies, and makes all the arrangements to get the customers' products to market. So Pittsburgh Logistics employees work closely with the employees of the carriers and the trucking companies because they've got to work through all these logistics and get the products picked up and delivered. So Pittsburgh Logistics wants to try to protect itself from having the carriers, the trucking companies, poach, steal, entice, solicit away from Pittsburgh Logistics its key employees. So Pittsburgh Logistics uses the following clause in its contracts with the carriers. Neither carrier nor any of its employees, agents, independent contractors, or other persons performing services for or on behalf of the carrier in connection with the carrier's obligations under this contract will directly or indirectly hire, solicit for employment, induce, or attempt to induce any employees of Pittsburgh Logistics Systems or any of its affiliates to leave their employment with Pittsburgh Logistics Systems or any of its affiliates for any reason. Now, the trial court held, so naturally, one of the carriers solicited employees away from Pittsburgh Logistics. Pittsburgh Logistics was not happy about that. It violated the agreement, and so it sued one of its carriers, and that's how the case got into court. The trial court held this provision void because it essentially forced a non-compete agreement on employees of companies without their consent or even knowledge in some cases. The trial court stated that Pittsburgh Logistics Systems should address its concerns about employees leaving and competing against it by having its employees sign covenants not to compete directly with Pittsburgh Logistics. Now, the Pennsylvania Superior Court affirmed, meaning agreed with, the trial court's decision. The Superior Court quoted the reasoning and rationale of a United States District Court opinion all the way over in New Mexico, and that court cited a Texas court's decision. That's how far these courts have to go to find relevant decisions, stating it is one thing to uphold the restriction on an employee's freedom where it results from an agreement freely entered into by the employee, but where the restriction on an employee's freedom results from the employer's agreement with another employer, the employee is derived of his or her freedom without acquiescence and with no resulting benefit. So, now, there are 2 points of interest here. First, the Superior Court of Pennsylvania may have opened the door to the enforceability of more narrowly tailored intercompany no-hire provisions. For example, it might be possible for one to be enforceable if it applies only to employees who work with the other company on the particular project subject to the agreement, as opposed to all of the employees of the company. Second, there's a well-written, cogent dissent from Pennsylvania Superior Court Judge Mary Jane Bowes, who's joined by Judge Mary Murray. The dissent holds to the contrary. It says the no-hire provision is enforceable under Pennsylvania law. The dissent explains how the no-hire provision is not a non-compete binding the protected company's employees. Instead, it binds the other company, and there's no basis in Pennsylvania law for treating a no-hire provision as a restrictive covenant between an employer and its employees. The district court found particularly persuasive the reasoning of the United States District Court for the Middle District of Pennsylvania's decision in Geo Decisions v. Data Transfer Solutions, LLC. Now, in that case, the federal court actually, that has jurisdiction over Pennsylvania in federal cases, actually upheld a no-hire provision under Pennsylvania law. It explained the purpose of the no-hire provision was not to restrict a company's ability to hire the employees of its competitors. That wasn't the purpose. Instead, the purpose was to ensure a temporary productive relationship between the two companies. And you can't have a productive relationship between two companies if the one company is trying to steal the other company's employees. That makes a lot of sense to me. Further, the court held companies have a legitimate business interest in making sure they do not become employment agencies for their competitors to whom they've exposed themselves working on these projects. Now, in short, the Pennsylvania Superior Court has held that intercompany no-hire provisions are void as against public policy, but it also, in my opinion, opened the door for more narrowly tailored provisions than the one used by Pittsburgh Logistics Systems. Further, the dissent in the Pennsylvania Superior Court decision in Pittsburgh Logistics, it actually provides a path for companies to challenge the holding of the majority. We'll see how these cases develop in the time to come. Now, that's about all the time we have today for the Scaringi Law Lunch Break. If you have any questions about employment law, covenants not to compete, if you're an employer who wants to consider a no-hire intercompany provision in a contract, don't hesitate to call the attorneys at Scaringi Law at 717-657-7770. Thanks for listening, and enjoy your lunch.